Welcome to Webinar Wednesday. Today's subject matter is Foreign Nationals in South Africa and the Labour Relations Act. Please take note that this webinar will be recorded, and by participating in it, you consent to this recording being made available on request. This webinar is scheduled from 10 to 11 and will consist of 3 parts. Part 1, introduction to our sponsor, LABCO Employers Organisation. Part 2, speaker for the day, Advocate Lodewijk Pinaar, regarding foreign nationals in South Africa and the Labour Relations Act. Part 3, question and answer session. Please take note, between Part 2 and 3, there will be a 5-minute break to refresh and to post your questions in the chat box. If you have a question that is not answered during the Q&A session, you are welcome to send it to our office via email on admin@leolaw, and we will respond in writing. Please ensure that your microphone is always on mute. It is now my pleasure to acknowledge our sponsor for this free webinar, LABCO Employers Organisation. LABCO has been registered and servicing its members for the past 23 years. LABCO is a membership-based employers organisation that strives to give expert advice and service to its members. We are firm believers in tertiary education, and our specialised team carries various degrees and qualifications from South Africa's top universities. It is this service and experience of our dedicated staff that we put at your direct disposal. We offer a vast wealth of knowledge, including, but not limited to, HR policies and procedures, wage negotiations, all union activities, collective bargaining, uncapped disciplinary hearings, uncapped CCA matters, dismissals and retrenchments, employment options and contracts. In line with our strong belief in education, we are very excited to announce the launch of our training module platform. The training modules will give your employees the knowledge to make sense of labour matters for employers. Does the following scenario sound familiar? John has not been pulling his weight and is not reaching the targets set for him. After a couple of weeks of constantly talking to John and asking him to improve his work pace to meet his targets, the foreman, on a not so good day, loses his cool and you receive a call to fire John. You go through John's employee file and there is no written warnings on record. You advise the foreman of this and suggest following progressive discipline. The foreman says the charge for the misconduct must be poor performance. You go through John's employee file again and there is no performance council record for him. In the meantime, the manager catches wind that John is not performing and that you advise progressive discipline in the form of a written warning, and you get the call, retrench John. What if everyone, from directors, managers, owners, down to the line managers, foremen, supervisors, had the same practical knowledge about labour law? How nice wouldn't it be if the entire company is on the same page when it comes to labour matters in the workplace? In this instance, if the how to prepare for a process training module was completed, the foreman would have known to ask for a performance council session for John, and the correct process is followed from the start. Our training modules can give you that practical training with a knowledge test and progress tracking of modules completed at an affordable price. As can be seen on the screen, these are the modules that are currently available. Companies can elect to have their employees attend all the courses, or you can customize which departments or management levels require specific modules. Courses start from as little as 300 Rand a module, and at the end of this webinar, we will provide you the link to access the training portal. On this portal, you will be able to view each of these modules and access them to get more information about the content of each module. This concludes part 1 of this webinar. It is now my pleasure to introduce our speaker for the day, Advocate Lodewijk Pienaar, to take us through part 2 of this webinar.
Good morning, everybody. Welcome to this webinar and thank you for your participation. I can see that there are still a few companies coming in, but we can postpone no longer. The purpose of today's discussion would be the definition of a foreigner, and specifically in how the government is currently, our government is currently dealing with the situation of the Zimbabweans. Just a few things. I can see videos are off. Just remember to stay on mute. You are more than welcome to, in the chat bar, to post any questions that you may have. We will specifically be spending time on answering those questions so that you are fully informed in regards to what you may require. Now, LABCA as an employers organization, we are definitely not immigration specialists. You are more than welcome to ask a copy of both the PowerPoint as well as the documentation from which we built this PowerPoint to ensure the accuracy of our documentation, as well as to see the complete documentation. Obviously, the PowerPoint would consist of extracts of certain documentation, but we are more than prepared to provide the documentation to you. So, Department of Home Affairs would be responsible for issuing work permits, visas, etc. And that is why we need to look at their definitions. Now, a foreigner means a person who is not a citizen of South Africa. Very simple. And any person that does not carry a South African ID and is therefore a citizen of South Africa and do not have citizenship anywhere else would have to have a work permit. This obviously would be the same if you were to go to England or America or wanted to work there. The same or similar regulations would be applicable there. Next slide, please. So the Department of Home Affairs issues work permits and visas. So a general work visa may be issued to foreigners who are non-South African citizens or permanent residents with the relevant skills. Now, just to state that a permanent resident automatically has the right to work. So even though they are still defined as a foreigner, they would have the right to work. So people that may work in South Africa without any additional paperwork would be South African citizens and people that carry permanent residency. The rest must apply for visas. A general work visa can be up to 5 years. Next slide, please. A critical skills work visa, the Minister of Home Affairs may issue or updates this list. And the challenge that we've got in our current format is that skills that are considered to be in short supply among South African workforce, and that they may require the proof of the qualifications and why no South Africans would be applicable. This is rather problematic, as the standpoint of the Department of Home Affairs would be that I will only issue a work permit if there are no South Africans that can do that particular position, and only then will I consider. Next slide, please. There is a list of critical skills, and you are more than welcome to ask our office for a complete list thereof. It is updated from time to time, but interesting. agricultural engineer, a business analyst, on the other side, a boiler maker, a financial investment advisor, a geologist, very interesting skills. But remember that if you do a critical skills work visa, you're up against the fact that there's no South African that can do that particular position. Next slide, please. This is an interesting visa. If it is a multinational company, let's say a bank, or Citibank, or whatever it may be, or a foreign-owned company, and you want to transfer employees, you can do an intra-transfer company work visa. Very interesting. Again, I'm not an immigration specialist, but something to look at. Next slide, please. A corporate visa, again, a corporation that would like to ensure that this corporation and whatever methodology and or culture is within the company that remains the same, would like to circulate some of its employees, and you could apply for a corporate visa. What is interesting is that the company, the corporate, must register with the Department of Home Affairs prior to such applications, indicating that they are a multinational that do move people around. Next slide, please. That, of course, brings us to where we are now, specifically with the ZEPs, the previous ZEPs, and the ZSPs, the Zimbabwean Special Permits. Now, for political reasons that we can guess at, but that's not been absolutely quantified, the Zimbabwean employees have been privileged enough to benefit from these Zimbabwean special permits. The idea originally was that we would have a SADC, a South African or Southern African Association, where we could, like in the United Kingdom, like in the European Union, relax our borders and have people work in different countries as long as the skills are there. And from that emanated only the Zimbabwean special permit. So no Malawian, no Mozambican, Swazi, Lesotho, no Botswana, nobody else benefits from this, only the Zimbabwean special permits. So the Zimbabwean special permits, they are currently guesstimated at 5 million of these Zimbabweans working in South Africa legally and providing services in various industries. And this is what we are looking at. So with a swift pen stroke, we'll show you a little bit later. This was called Interlife. It was then cancelled. It was then extended until the 31st of December. And it has now recently been extended again to the 30th of June, 2023. There is no guarantee that it will be extended beyond this date. It is the third extension. I do believe in an election year, it will become a burning issue that will unfortunately become a political playfield. And we as employers must ensure that we are on the right side of the law. Next slide, please. Now, I had to put this in the slideshow. If you look at the notice of Department of Home Affairs, it is a single sentence. Kindly note that Immigration Directive number 10 is hereby withdrawn. It was as swift as that pen stroke that the ZEPs came to an end. And on the extension, it was another single sentence requested and decided to extend the period for the further 6 months, that is 31 December to 31 June 2023. The legal process that led to this has not been shared with us. It was just a decision that the minister made. The reason why that's kind of interesting to myself, if I know what moved him in the first instance, I could guess what would change his mind going forward, but the minister simply decided. Next slide, please. What is the consequences of transgressing a law? The South African Police Services are there to police, pardon the pun, the laws of our country, and specifically the South African Police Service. So they work in conjunction with Department of Labor, Immigration, and then of course Immigration, they've got their own police force, and then the South African Police Force. They have a very strong arm approach to transgressions of immigration laws, unfortunately. The reality is that if you as the employer are knowingly or unknowingly transgressing immigration laws, the van will take away both the employer and the employee. So whoever is the manager or the site agent or the MD or the owner, if they as immigration and police find that you are employing illegal immigrants and you're transgressing immigration laws, it is a crime, and they forcefully, unfortunately, enforce that, and we would have to arrange bail for both the employer and bail for the employees. The employees are deported, and the owner would possibly sit with a criminal record. Thank you. Next slide, please. The South African Labour Relations Act, unfortunately or fortunately, looks at this problem differently. In terms of the Constitution of South Africa and the human rights, the right to a fair dismissal is extended to foreign employees. Be they illegal or illegal, they carry the right to have a fair dismissal. So the conundrum is that it is illegal to employ them, but it is illegal to dismiss them. So how, as the employer, are you going to deal with the foreign workers or employees that were legal but have lapsed in their passports falling away, or that they don't have work permits, or that they pass beyond the ZEP extension? How are we going to deal with that? We've had the situation where we literally sit at the CCMA for an unfair dismissal, and client just simply fired the Zimbabweans because he thought that they were illegal. So while we were doing the arbitration, the South African Police Service and Immigration were waiting for the same employees downstairs to send them back home, but they still managed to win that case. So the Labour Relations Act protects them against unfair dismissals. Next slide, please. Political interference. Now, there are various operations going on. The one that's referred to as the pushback and various civic movements, vigilantism and xenophobia, unfortunately also thrive in these uncertain circumstances. I've got a challenge as a legal advisor to look at the political or the economic opportunism versus genuine concern. The way that we found it playing out would be that you would find in specific to the big centers, some of these movements arrive at the employer's place of work with boatloads of South African CVs. They would then make a substantiated or unsubstantiated claim that there are illegal foreigners working in the company, and that they demand that those employees be dismissed immediately and replaced with South Africans. Now, we've found that these CVs, they actually sell this opportunity, so they are getting paid to collect these CVs, and obviously they will get paid once these people get jobs. So economic opportunism. I would not, my advice would be, if you are confronted with a political party, with one of these operations or anything that does not come through a union that you recognize, that you do not enter into direct contact with them, but phone our offices immediately. There are many traps to set in. And again, once they are inside your workplace, it is very difficult to exit them outside of the workplace. There are fair and proper mechanisms to deal with this. As the employer, the first place would be that you know your workforce, that you know who are South Africans, who have work permits, who do not have work permits, who are ZEPs, that you know that if there's a claim, it's substantiated or not. If we, as the employers organization, on your behalf are confronted with this situation, our advice would be to phone the Department of Labor and Immigration and tell whoever's at your door with a bunch of CVs to please allow the Department of Labor inside so that the impromptu inspection can be done and get it sorted out that way. It is impossible to negotiate your way out of such political or economic opportunism, and they really create chaos and havoc in your place of work. Next slide, please. I know that I've gone through this rather quickly. Whilst we are contemplating the questions that you may have, let me just say that if you are an asylum seeker is not a work permit, but while you are seeking asylum in South Africa, you are allowed to work. So if you've got permanent residency, if you've got a valid work permit, or if you carry a exemption while you're waiting for your South African citizenship, you may work. For the rest, the employer carries the responsibility to act as we would be an agent on behalf of SARS to make sure that taxes or pay-as-you-earn and UIF is collected. We also carry a fiduciary duty to ensure that we carry at least a basic understanding of the immigration laws and what's the difference between an expired passport and a valid passport, an expired ZEP and an extended ZEP. I'm going to allow for a few minutes. I've taken up half an hour with my presentation, and let's just take a few minutes, just drop them in the chat bar below, and Emmy will take me through them one by one, and we'll deal with the practical issues. So let's take a 5-minute break, and we'll be back in 5 minutes. Thank you. Okay, thank you, everybody. I'm going to ask Emmy to fire away at the questions that I've received. Thank you.
What can companies do to assist employees to obtain work visas?
So let's just start in any other work permit except a ZEP. It is indeed the employer that applies for the work permit on behalf of the employee. So any work permit except a ZEP, quite frankly, the employer is responsible for applying for that work visa, and the employer gets the work visa. So it'll be my name, but it'll be attached to specific work at the employer. When it comes to a ZEP, there the employer can do nothing. It is my view that even though the period for ZEPs has now been extended, that there is not currently any resources at Department of Home Affairs to effectively deal with the renewals. I can only suggest, and I trust, that come January or February 2023, when Department of Home Affairs has had an opportunity to get its affairs in order, that the ZEP renewal process will start in earnest. I can honestly say that there has been zero, to my knowledge, zero successful applications even on the 31 December deadline that's now been extended for 6 months. So in short, for ZEP, there's nothing the employer can do.
We have 2 asylum seekers that have been placed on a short list to go over to Canada. This should have happened 2020, but due to COVID was extended to January 2023. Their asylum visas, however, expire at the end of the month. What steps can we take?
Kind of relates to my first question. An asylum seeker is again one of those things that the employer cannot do. The employer is not granting asylum or applying for asylum. So those asylum seekers would have to get their asylum extensions done on their own. Again, I don't know if the capacity is there to deal with it. I can honestly not think that they would get arrested and deported back to the country of origin because they are already almost in transit overseas. So that would be an absolute exception. And I would guess that that would be an acceptable risk to keep them on. Thank you.
We have a foreigner working for us. His passport and visa is up to date, but his visa states that he's a critical skills worker. If we appointed him in a position that is not part of this critical skills list, will we have a problem?
That sounds like a very practical problem, and please contact me directly later. But the answer would be that if he's got a critical skills visa, that critical skills would have to be one of those in the list or previous lists that has been brought out. And we would have to ensure that what you are employing him at would kind of match any of those critical skills. That's a very practical question. I don't think Department of Labor would, or Immigration, they rarely go and look and see what they are doing. They generally sit in HR office and go through the paperwork and decide from the paperwork whether arrests would follow or not follow. I have not yet seen them literally going through and seeing what work is being done. So I think if your paperwork on office level is okay, I think Department of Labor would just move on to the next one.
Seems like we have a very intelligent participants today, because there's very few questions in comparison to the previous webinars. That is all so far. So please, if anybody has a question, either raise your hand. If you don't like typing, you're welcome to put on your audio and ask the question. We are ready and waiting. Oh, very interesting question. So if you marry a South African citizen, do you have any issues? Or are your issues over then?
It depends on whether it's a happy marriage. So I don't know. If you marry a South African, you do not necessarily automatically get permanent residency and a work permit. So it would depend on your permanent residency combined with the marriage certificate. So no, it is not, marriage is not an automatic loop out of this.
Our CEO is the owner of the company and Canadian. Are there any special circumstances that could assist with obtaining a work?
So that would definitely be one of those first two, the multinational work permit. And I would definitely say that kind of for obvious reasons, we as Department of Home Affairs would issue a work permit. But yes, there's specific provision for such a scenario.
Any other questions we can assist with?
Whilst people might be thinking, let's just say, what is our advice in regards to a person that's got a work permit? The first thing to state is that any person with a work permit can only be a temporary or fixed term worker for the duration of the fixed term contract, of the work permit, I apologize. That person cannot guarantee that they will be legally able to work for you until retirement age of 65 or 70, because they can only guarantee their presence as long as they've got a work permit. So the first thing that you'd have to do would be to align your contracts of employment with your work permits. There's a specific provision in the Labour Relations Act that says fixed term contracts should only be for 3 months. But one of the many exemptions on that would be a person that's got a work permit. So you could renew their fixed term contracts many times, but only in line with their work permit. This, of course, gives the employer the opportunity that if the work permit were to expire, the contract of employment will expire similarly, and therefore it will not be a dismissal. So the employer will protect its rights in regards to not having to go to the CCMA, because the paperwork is reflecting the fixed term nature of this agreement. If you've got employees on work permits that somehow have permanent work status or permanent contracts with you, that's a misalignment, and we should and must assist you with resolving that issue. Otherwise, you're going to sit with an illegal immigrant that could cause you serious risk and harm, but the risk of also losing at the CCMA for an unfair dismissal.
The question then from the practical perspective, I think, has now been answered by Mr. Pienaar. How can the employer double check whether a work permit is valid?
Now, Department of Labour is, for all the challenges that they might have, very open to advising and assisting the employer. Quite frankly, if you were to push your inquiry through Department of Labour and you are waiting for feedback, nobody could reasonably expect you to know the answer, and that would be a very good bail application and or further applications. But you can please contact our office and we will share what we've got as to how to use Department of Home Affairs to double check work permits.
If existing Zimbabwean employees are fired but prefer to stay on off the books, is the employer exonerated?
I'm glad this is anonymous, but the answer would be no. If you smuggle drugs off the books, you are still committing a crime. So no, it would remain a crime. Quite frankly, you would be now committing further crimes because you would not be contributing to UIF. You would not be contributing to the compensation commissioner, and you would be just transgressing more laws. So a very bad idea, very, very bad idea. I would not recommend that route.
Mr. Pienaar, can I maybe just also jump in here from a practical point of view?
Yes.
It is highly recommended that companies do an audit of their employees, and specifically to establish who is foreign nationals, and then your foreign nationals to further do an audit to see on exactly what permit they are here and when it expires. I think we must also then maybe just give a suggestion that you don't want to rock the boat right now. The discussion you and I had yesterday about not doing anything until January, February, can you maybe elaborate for our participants on that?
Thank you. So an audit sounds rough, right? What Emmy actually would mean is that if Department of Labor arrives, you must, just one of the basic things, have a list of all employees that you currently employ. And those employees must be marked as South African citizens or foreign nationals. So first off, you should have a list. If you do say that they are a foreign national, it would be advisable, Excel spreadsheet, whatever you want to require, to capture their passport number, the expiry date, what visa they are on, and the expiry date. Taking into account that ZEPs has automatically been extended, you can simply put the date of 31 December, I apologize, 30 June on there. We trust that the paperwork will follow. In regards to rocking the boat, it's the last 90 working days of the year. And speaking from a human perspective, I'm sure that a ZEP holder is stressing at this stage. If you now come and want to change my permanent contract to a fixed term and put additional pressure on me, I'm just concerned that production may suffer. I would therefore advise that come January, February, when everybody's afresh, that we handle the movement from permanent to fixed term or alignment with work permits be done in January, February. I also think that, I hope and I trust that come January, February, Department of Home Affairs would have its affairs in order to be able to process all the ZEPs. Currently, they are not doing any of the work that they should be doing. I hope that with this extension, there will also be some finances released towards this project, and therefore my advice would be to tell employees to pin their hopes on January, February next year to have their visa or ZEPs then extended and get the correct paperwork done. For now, the extension that has been granted, it does not say that you must apply for the extension to be applicable on you. It just says it has been extended. So very plausible deniability in regards to any criminal activity in that regard.
If we are aware of foreign nationals that is currently working with a South African ID that they bought from the black market, what can happen when we get a labor inspection?
fact that you know that a crime has been committed does not bode well. The black market immediately should ring criminal activity. So that would not be any excuse. You will most probably find that if you attempted to register that ID number for UIF, that it would not allow you to do so. And the main question would be, how can you employ a South African, if you believe that they're a South African, but you're not paying over UIF? So that is an exercise in futility and an additional transgression in terms of our laws in South Africa. Stay away from that.
Does all of the above relate to students in the country that have had their visas lapsed? In other words, should we house them, or where does that leave us as a landlord?
A landlord. So this would not be a labor-related issue. So let's just say a student visa would entitle me to study, not to work. So a student visa would not assist you with immigration, and Department of Labor, it would not grant any excuse. If it comes to the civil question of, may I rent out a property to a person that does not have a work permit or staying permit, I'll be honest with you, I don't think that a rental agreement would be a challenge. And I'm just thinking, under what scenario would a landlord know about visa statuses? I find that a bit odd question, but it's definitely not labor related. On a civil side, I think you can rent out properties to anybody.
Is incapacity the correct way to terminate employees who have full-time or regular status or contracts with lapsed work permits?
No. It is not an incapacity, it'll be an impossibility of performance, and we will definitely please contact us so we can look at your specific scenario and we can resolve this issue so that you don't end up at the CCMA. So this is a very specific question and it's unique to each set of circumstances. Please contact us so we can provide you the solution.
I don't have any other further questions. Anybody who has any?
Very much. So let me just move on to the next part, which would be our training modules. And please, if you've got any additional questions, don't hesitate to contact us. We've shared with you those 10 modules, and the whole idea of them is at 300 Rand a module. I don't think it's a huge amount of money, but 2,500 for the full module. That would be all 10 modules. They are knowledge-based, which means that it is an online platform where you'd have video advice, giving you not academic advice, but practical advice in regards to what's the difference between an incapacity and a misconduct, and what is a probation period, and how do I prepare for the CCMA, how do I prepare for a disciplinary hearing. These are very practical things. And the whole idea would be for the employer to ensure that all its managers, at least to a certain level, have this practical understanding of labor laws in order to make better decisions. So we will be contacting you. You're more than welcome to contact us to have a look at these webinars. But the idea for our client base or any employer would be to ensure that the whole organization at least understands the basic principles of labor law so that they make good, informed decisions and don't waste such money at the CCMA for doing a misconduct hearing where it should be incapacity or an ill health or not understanding what a probation period is. As we are looking at the contracts of employment, you will definitely see what a fixed term contract would be. So in the background, we are running the basics of, what would be in some of the elements of of the module. And please have a look at that. We are definitely running the special for the rest of this year. So please have a look and sign up today, and let's start Get Learning. Thank you very much for attending today's webinar. I'm going to end off by just going through the slideshow with you, or just looking at it, and please give us a call. Thank you very much. Thank you, Emmy, for your advice.